Welcome to the Australian community. Today, we're speaking with Peter Harper, who is a managing partner of ASENA Advisors. Peter has an LLB from the University of Queensland, a Master's in Taxation from the University of New South Wales, and is also a registered US tax advisor. Most recently, Peter has become a director of the Australian community. This afternoon, Peter will be discussing some of the changes to Australian tax law which is impacting Australian expats. Peter, welcome.
Thanks, James. It's great to be here.
Peter, it seems a little bit like Groundhog Day, but here we are again discussing superannuation and FBAR and FATCA. Peter, it seems that misinformation is still floating around the internet that people do not need to file an FBAR if they have superannuation. Perhaps we can just put a nail on that once and for all.
James, categorically, people should be filing an FBAR with respect to their superannuation account.
Look, we're going to put some links in the video below that will link to previous videos that will discuss this in very great detail. I did want to mention that because I still am receiving emails from members saying, I've been here 6 years, 7 years, and I thought I didn't have to file it. Now, if someone does find themselves in that situation where they do need to file an FBAR and they have been a resident alien for a number of years, there still is a way to proactively go out and try and avoid some of the fines that would be normally associated with that.
Yeah, if you can show that your actions were non-willful and that there is a reasonable basis for you omitting the account on your FBAR, it is possible to remediate those penalties.
Now, on to another subject, Peter, which has just recently become an issue, and that's recent Australian changes to Australian law affecting expats, those that are obviously for their taxes outside of the US, but also those that are visiting Australia, especially during COVID, for perhaps a longer than normal period. Can we talk about those two areas, the residency changes and also the treatment of foreign tax?
Sure, absolutely. So there has been a substantial overhaul in the structure of the Australian residency rules to try and modernise them. The old rules heavily focused on facts and circumstances of an individual taxpayer. The new rules are actually very closely aligned to the UK rules. So they've using what's called this bright line test. And so there's a lot of misinformation out there on the internet right now to say that, there's 45 days, you can become a resident. There is a bit more to it than that. And in my opinion, these residency changes are a positive thing rather than a negative thing. So that there is a requirement that it is true that if you, under the new rules, which is the same under the old rules, if you spend more than 183 days in the country, you're going to be a resident, right? That hasn't changed. The big change is to try and align through just general principles or really, really easy to understand concepts what was previously a test that was very much driven around facts and circumstances. So first thing, you've got to be in the country for a minimum of 45 days. And then you have to satisfy at least two factors of what's called the factor test, right? So that's either that you have a right to reside permanently in Australia, you have access to Australian accommodation, you have Australian family or Australian economic interests, right? A lot of people hear that and their immediate reaction is they say, well, I've got Australian family or Australian accommodation. It's not exactly how it sounds. Australian family does not mean your mum or your dad. It means it's thinking about the concept of someone with a spouse and children in Australia that's travelling in and out of Australia, right, in the context of the family. And accommodation means you've actually got to have a right to reside in Australia. So you own a property that's vacant, or you're leasing a property, or there is some form of habit. So maybe you are spending time with family, but you're consistently, in and out of the country. So Yes, there are changes, but in fact, it's going to make it a lot easier for people, I think, to navigate in and out of the rules. The other thing to just keep in mind, even if someone is a resident under these new rules, because it's easier to become a resident, if you're still spending more time in America, when you apply the tiebreaker test under the treaty, you will still you can still be a non-resident of Australia, right? So, me personally, I don't think these rules are going to be as big of an issue as some commentators are saying. Importantly, they do have application from 1 July of this year. We have not yet seen draft legislation, so we've got these concepts that have been outlined in a previous report, but the devil's going to be in the detail when we receive the legislation.
So, Peter, if someone is visiting Australia, say for 60 days, they're normally resident outside the US. Let's say in September of this year, they go for a month or so, more than the 45 days, and they take their family with them, and they're staying, say, at their house that they normally have in Australia, but the renters aren't there for that month, or some scenario like that. Is that going to automatically make them a resident, or do they have to?
That would make them a resident, but I think the big unknown that was lost on a lot of people, the old rules said that you are a resident of Australia if you intend to reside in Australia within the ordinary meaning of the rules, or if you're domiciled in Australia. I mean, when I say that, everyone's sitting there going, well, what does that even mean, right? That's right, which is the right way to think about it. But under those rules, it was extremely easy in that exact same scenario. That person probably would have been a resident under the old rules, right? It's just that in this change that's happening now, it's far more clearly defined. It's actually a lot easier for me to sit down with someone. You take that exact same fact pattern. If they went back and they only went back to Australia for 40 days, categorically not a resident, right? So I think, or if they went back and they stayed for more than 45 days but stayed in a hotel, right? So I think there's still going to be flexibility in these rules, and in fact they're going to be easier to navigate.
So just to wrap that up, so let's say, for example, I do intend to return to Australia and I have had an apartment there or a house that I've been renting out, and I, ask the leases up for the tenants, and I move my family over there, and I have every intention of becoming an Australian resident again. It's going to be within 45 days. I'm essentially can reapply for Medicare and all those other Australian social services, etc. Whereas before, it may not have been so clear cut. Correct?
Yeah, correct. I think that's the right assessment. I think if you think it's a positive thing to have clarity around these things. So even if, it's easier for people to navigate, right? Then I think that's a true statement.
And also too, just on the contrary, that if I am planning an extended stay in Australia, but I'm staying at a hotel for 3 weeks in Sydney, then notwithstanding restrictions, I fly to Melbourne for a couple of weeks there, or then rent a van and travel around Australia. That would not classify as residency because I'm not abode in any one address, correct?
Yeah, you're right, automatically. You're not automatically. So even if you spend 45 days, more than 45 days, if you're traveling around the place, you still need to look at these other factors, right? Whether you've got an economic interest, but I think even if that's the case, even if there is a risk that you're going to create residency, if you're operating in that way and you're still connected to another country, then you're likely going to have treaty protection anyway. When COVID hit, and this happened all around the world, countries all around the world said, you know what, we're going to add flexibility to our residency rules because people are being stuck in various places. The US did the exact same thing. Right, so people, there was a lot of focus on residency rules everywhere around the world at the time. In Australia, there was leniency. So if you went back to Australia, you got stuck there. There's all these facts and circumstances, right? You got to try and prove that you had intent. The ATO came out and said, okay, well, we're going to be flexible on that if you're trapped in Australia. They did then come out and say that if you have an ability to leave, so if you've been trapped for a period of time, but then you do have the ability to leave, right? So you can physically get your family together and go back. that is when they were going to start to reapply the same traditional rules, right? So I think this is actually one area where there's been a great deal of misinformation, because there was a view for a period of time that there was just a general relaxation of residency rules everywhere around the world. I think that, you know, as the lockdowns kind of re-emerge again in Australia, there likely is going to be, again, more flexibility, you know, in Australia. But if you look at the US, for example, it's back to business as usual. There's no flexibility anymore as far as America is concerned if someone's stuck in America.
Peter, also I understand that there's been some changes to the treatment of Australian expats with regard to Australian taxation. Can you talk a little bit about that?
Yeah, James, I can. I mean, I think the most recent change was that the main residence exemption was abolished for people living outside of Australia. So historically, you could be outside of the country and you could sell your primary residence, and there were still rules that allowed for you to reduce the capital gain under the main residence exemption. There was also a change. It's a long time ago now, but really these two rules, we think about them in together, was the general discount, which is the rule that allows you to reduce the capital gain in half if you've held an asset for more than 12 months. That was taken away in 2012, right? So there has really been this movement from a political standpoint within Australia to levy higher rates of tax against Australian expats or non-Australians versus Australian residents, right? And so, you know, we see this trend continuing. We don't see this softening, and you know, it has a whole bunch of different implications that extend past, you know, real estate to how people sell businesses that might be, you know, held in both countries, and you know, it is one of those things that's a big issue.
Peter, I want to thank you again for your time this afternoon. We really do appreciate your time in explaining these changes to our members. Thank you.
My pleasure, James. Thanks for having me.